Welcome to meeting number 85 for the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference adopted by the House on June 21st, 2023, the committee is continuing its study on Bill C-40, an act to amend the Criminal Code to make consequential amendments to other acts and to repeal a regulation, miscarriage of justice review. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23rd. Members are attending in person in the room and remotely using the Zoom application. I note that the witnesses that we have for the first hour are all attending by Zoom, so I will make a few comments. Please wait until I recognize you by name before speaking. Click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. I have these cue cards, and I know it's difficult when somebody's on a roll and speaking, but I will raise the 30 seconds when there's 30 seconds. I'll raise the time is up when the time is up. If the speaker has a couple of seconds left, I will let them proceed. Otherwise, I will need to interrupt. Don't take it personally, but unfortunately, that's how things work around here. I want to confirm, je veux confirmer que tous les tests sonores.
I would like to confirm that all sound test was successfully done with all the witnesses this afternoon. Thank you.
Bien plus tardé, souhaitons la bienvenue aux témoins d'aujourd'hui.
We would like to welcome our witnesses. Today we are working on a study on Bill C-40. As an individual, Neil Weiberg. By video conference, Nikki Kish, Associate Executive Director, Canadian Association of Executive Rights Societies, Tony Paisana, Canadian Bar Association. Each witness will have 5 minutes.
Remarks, and after we will go to questions from the members. Alors, the floor is yours, and I will ask Monsieur Weiberg to please commence.
Thank you. My name's Neil Weiberg, and it's an honor to appear in front of you. Just a little tombstone information. I was called to the Bar of Alberta in 1984. I was appointed QC in 2006, and I transferred to the Bar of British Columbia in 2018. I'd also like to say that when I was in the Kamloops office, I was the Deputy Regional Crown Counsel. I was honored to work with Frank Caputo as one of the prosecutors in our office, and he was an excellent prosecutor. Frank first asked me to talk about how often we receive these type of reports from the minister. And in my career since 1984, I've only seen one. And that actually was this past year. It was a case in British Columbia and Kamloops where an individual was convicted of first-degree murder. It turned out there was some change in the science of drowning and hypothermia, and some recent evidence came from new forensic pathologists that put the first-degree murder conviction in doubt. There's no doubt this accused committed a sexual assault and killed the victim, but it actually should have been a manslaughter rather than a murder. So this individual, the minister made the report, and the Court of Appeal reversed the decision and entered a stay on the murder charge. So I've only seen one in my career in both Alberta and British Columbia. I'd also like to say that since I began my career, a number of steps have taken place that I think are very positive, that have reduced the chances of of wrongful convictions, first of all, was disclosure. When I started out in 1984, all that was provided to the defense was their client's criminal record, their client's statement, and a synopsis of the facts. Nothing else was disclosed. Witness statements were not disclosed. Police reports were not disclosed. Police notes were not disclosed. So if there was tunnel vision that was obvious from seeing those documents, the defense would have no idea and wouldn't have seen those. So cases like Morin, Marshall, Milgard, there wasn't disclosure provided in those days. So the Stinchcombe case that came in 1981 that orders all disclosure on all relevant materials is very, very helpful. Number two, DNA has really changed the scope and reduced, in my opinion, the number of possible wrongful convictions. DNA not only convicts individuals, but eliminates individuals. And I had a case when I was in Lac La Biche, a very, very strong circumstantial case where there was some hair evidence. And I thought there might have been reasonable and probable grounds to lay a charge of murder. But the police came to me and said, there could be DNA available, not the nuclear DNA we're associated with, but mitochondrial DNA. There were hair shafts in the victim's hands, and as well, there was hair plucked from a general warrant from the potential accused. The mitochondrial DNA was not available to be analyzed in Canada, but it could have been in North Carolina. So as the Crown responsible for the case, I said, this matter has to be examined, send the DNA to North Carolina. And the samples were sent to North Carolina and it came back not a match. So think of it, this individual was inconvenienced for 15 minutes while a DNA sample was taken. And it turned out he was never charged because the DNA was not a match. So the acceptance of DNA as a science, the DNA warrant regime, and the DNA data bank has greatly helped, in my opinion, reduce the chances of wrongful convictions. Third, there's cameras everywhere now. So you don't always have to rely on eyewitness testimony. The fact that there's cameras everywhere is very, very helpful in prosecuting cases and getting to the truth. I had a sad case in Edmonton where an 80-year-old woman was run down by a city bus. We suspect the bus driver might have been speaking on a cell phone, but the video showed clearly that the woman was walking within a crosswalk and she waited for the walk light to come on. I'd also mentioned photo lineups have been changed. I also mentioned in custody informants are rarely used anymore, and those were a big problem. Provinces have adopted tunnel vision rules. I was the Crown in the Mayerthorpe case, and I spent 2 years giving pre-charge advice to the police. But once charges were laid, I was no longer the Crown because for tunnel vision purposes, someone else comes in. Final point, we had James Lockyer and other people like that at our conferences.
Why don't you save that point for questioning? So let me now go to Madame Quiche. Thank you very much to you.
Thank you. Thank you, honorable members, for inviting me to be here today. Since 1978, CAFES has been the leading national organization supporting women and gender diverse people at all stages of legal system involvement. We conduct monthly visits into Canada's federal penitentiaries for women. Our 22 Elizabeth Fry societies nationally provide a range of services in prison and in the community, including operating halfway houses, providing court support, diversion programs, and beyond. Through this work, we come to know closely the people who this bill impacts. We welcome Bill 40, but caution that amendments are needed to ensure the Act can meaningfully respond to miscarriages of justice. Most women and gender diverse people who become incarcerated are critically disadvantaged. The system is in crisis, with half of people in prisons designated for women being Indigenous. Much attention has been called to the systemic and social factors that lead women and gender diverse people to become wrongfully convicted. And the justice system rests upon its ability to be just. Yet we posit that presently, miscarriages of justice for the populations we serve are systemic. This is in part as conditions within our provincial jails are deplorable, characterized by frequent lockdowns, isolation, poor food sources, dismal healthcare, very expensive, restrictive access to family and beyond, and up against losing their children, their employment, their housing. Many disclose to us that they plead guilty regardless of whether or not they are, in order to get out faster. So from our perspective, pleading out is a very common experience where individuals make the best decisions that they can within a forced choice where no outcome is a good one. And we receive almost constant requests to help people redress their convictions. Many share how their previous lawyers discouraged them from filing appeals and often encouraged them to plead guilty in the first place. We direct people toward innocence projects and watch the lengthy process unfold. Often we see them give up. And the pressure to be guilty doesn't stop at a verdict for the wrongfully convicted. Once sentenced, we see women and gender diverse people who maintain their innocence experience a number of punishments and exclusions because they are not seen as taking responsibility. So this begins with being denied access to core correctional programming, which is a precursor for access to a host of additional programs and services, and a requirement to move to less restrictive security classifications. Much of what it takes to survive incarceration, visiting family, accessing work and education, and accessing the legislated process of gradual release, these are significantly restricted to people who maintain innocence via their being kept in higher security classifications, and as most supportive processes are only conditionally approved. For each one, prison officials must complete assessments for decisions, of which primary considerations are the level of responsibility and institutional adjustment that a person demonstrates. Well, it's very difficult to be assessed as adjusting well within an institution whose programs you cannot participate in. So doing well in prison and reintegrating into the community via parole becomes next to impossible, and people either become pressured to indicate guilt in order to successfully navigate the system, or maintain their innocence and face a harsher version of incarceration, which elevates risk of chronic adverse mental and physical health outcomes and institutionalization. We've submitted an associated brief, which emphasizes amendments that ensure incarcerated applicants aren't punished as a result of pursuing redress, which endorses UBC Innocence Project's key amendment to legislate the possibility of exceptional review where appeals have not been exhausted, and which legislates defined timelines associated with the commission, as perhaps nothing could be underscored more than the irreversible impacts on the life course of wrongfully convicted people. At present, wrongful convictions take years and more generally decades to overturn, and life is simply not that long. We witness the cumulative loss experienced, especially for those with long and life sentences, loss of mental and physical health, of family and social connections. And time is an irreturnable resource to take from people, and we don't often contemplate its associated costs, the loss of milestones.
Let me stop you for a moment. Apparently, we have difficulty in the room with no translation. One moment, please.
Sorry.
Okay.
On va appeler ça simplement un problème parlementaire.
We'll call this a parliamentary problem.
Oui?
Oui,
Oui?
je vous entends.
Oui?
We can hear you.
Okay, merci. Please continue.
Okay, thank you. I'm sorry. So time is an irreturnable resource, and we don't often contemplate its associated costs, such as the loss of milestones or rites of passage. But we see many women and gender diverse people lose their reproductive years to miscarriages of justice. They lose love, marriages, divorces, careers, career changes. This is the stuff taken, and this is the stuff life is made of, and we only get one life. So there will be a material and significant benefit to the goals of justice and to safe, fair Canadian institutions through establishing the amendments offered in our brief and those offered by our colleagues. I look forward to answering any questions you may have, and thank you.
Thank you very much. I will now ask Monsieur Paisana to please proceed with your remarks.
Thank you for the invitation to present the CBA's views on Bill C-40. I'm the past chair of the National Criminal Section. I've worked with the UBC Innocence Project for the past 10 years, and I teach at the University of British Columbia Law School a course on preventing wrongful convictions. As you know, the CBA is a national association of over 37,000 lawyers, students, notaries, and academics. An important aspect of our mandate is seeking improvements in the law and the administration of justice, and that's what brings us here today. Our submission was prepared by the National Justice Section, which comprises both Crown and defense lawyers. The CBA supports Bill C-40 and offers some suggestions for improvement, two of which I'll highlight in my remarks. Before doing so, however, I wish to express our clear support for some aspects of Bill C-40. For decades, lawyers and others have labored under a slow, difficult to navigate system for post-conviction review. Bill C-40 represents a sea change in how post-conviction review work will be done in this country. It is a welcome change, one that we will hope means miscarriage of justices will be rectified, and more importantly, rectified more quickly. The creation of an independent commission, we hope, will improve the transparency and efficiency of post-conviction review. And in particular, we support the new standard of review contained in Bill C-40. The existing standard, reasonable basis to conclude a miscarriage of justice likely occurred, is cumbersome, difficult to apply, and leaves many potential wrongful convictions outside the ambit of review. The new reasonable grounds to conclude standard solves these issues and is a welcome development. In addition, we applaud the federal government's explicit inclusion of posthumous cases in the Commission's mandate. Wrongful convictions affect not only the accused, but their family, friends, and wider community. Allowing for posthumous review provides an avenue for those affected by wrongful convictions to seek redress. In terms of improvements, our brief lays out some of those areas. We support some suggestions made by other witnesses who have already testified, and I'll highlight 2 points as I mentioned. First, as set out in our brief, we support the inclusion of a new unsafe ground of appeal to be included in the criminal code. The most important and immediate step of rectifying a wrongful conviction exists in the Court of Appeal. Indeed, for the vast majority of accused persons, it is the forum of last resort. However, the Court of Appeal is a statutory court, meaning it's specifically constrained by the criminal code. Where the court is faced with a case that does not meet the exceptionally high threshold of unreasonable verdict, they cannot intervene, even if a lurking doubt exists as to the accused's guilt. Unsurprisingly, given this landscape, many of Canada's most infamous wrongful convictions were unsuccessfully appealed, sometimes more than once. Indeed, there is a strange history of some of Canada's leading appellate cases being connected to wrongful convictions. The leading case on unreasonable verdict, in fact, was the Yeebies case, a recent BC miscarriage of justice, a murder conviction that was overturned nearly 40 years after the fact. One of the leading decisions on confronting hostile witnesses, Milgard, bears the name of the namesake of this legislation. In dismissing Mr. Milgard's appeal in 1971, the Saskatchewan Court of Appeal said that the evidence could properly be found to support the verdict. That is, it could have, as opposed to it must have. As you see, the could standard is a low one on appellate review, and there is a duty to prevent wrongful convictions at every stage of the process, including specifically on appeal. And changing the criminal code to add an unsafe verdict would address this issue. Our second area of improvement relates to the eligibility criteria for the Commission. We echo the concerns raised by others that the mandatory requirement of appellate final decision will potentially create a significant barrier to wrongful convictions becoming uncovered. Those who enter a false guilty plea, for example, will have to go through the complicated and awkward process of trying to overturn a guilty plea. Having falsely pled guilty, there is a strong likelihood that these individuals are unsophisticated, intimidated by court process, and are otherwise at a disadvantage in navigating the appellate regime. And make no mistake, bringing an appeal is complex and requires expertise. Ivan Henry's wrongful conviction is a poignant example of what this barrier might do. He was convicted in 1982 and designated a dangerous offender. Unrepresented, he filed numerous applications and failed at various courts and ministers to review his conviction. In 1984, his appeal was dismissed for want of prosecution because he had not filed transcripts. He never had an appeal and never had a final judgment. He would therefore be ineligible for the current regime. This, I say, is a problem and should be rectified by a simple amendment, treating an accused who has not had an appeal the same as one who has had an appeal but has not appealed to the Supreme Court of Canada. That is, a factored analysis where it is just one factor to determine the eligibility, the fact that they have not filed an appeal. The legislation currently contemplates that very process with someone who has not filed leave to the Supreme Court of Canada, and there's no reason that this cannot be extended to accused persons who have not had an appeal. Those are my comments. Thank you.
Thank you very much. We will now begin with our questioning for 6 minutes each, and we will start with Mr. Moore.
Okay. Thank you, Madam Chair, and thank you to all of our witnesses for appearing today and offering your perspectives on this legislation. Mr. Weiberg, you seem like you were just wrapping up your remarks, so I only have 6 minutes, but I'll give you 30 seconds or so if you were just wrapping up, if you wanted to finish your thought.
Yes, I was just going to say it's the role of a prosecution service to make sure all the Crowns are aware of wrongful convictions. And I know when I was in Alberta, we had James Lockyer as a guest speaker, and he told all of us about the history of wrongful convictions, the problems the Crown should look for. And that's one of the obligations I think a prosecution service has. So also as a result of the Sofino Committee, our executive brought in new changes to photo lineups based on scientific research, the discouraged use of in-custody informants, that they're almost never used because they're very dangerous and contribute to wrongful convictions, and also rules for tunnel vision.
Okay.
Thank you.
Thank you, sir, for that. So I'm back to you, Mr. Weiberg. You, Frank Caputo is unable to be here today, but I will pass along your comments. But
yes.
Yes, he'll like everything that you said for sure. But I do want to ask you on if you have any thoughts on the threshold that's being proposed in Bill C-40, moving from a reasonable grounds to conclude that a miscarriage of justice likely occurred to a reasonable ground to believe that a miscarriage of justice may have occurred. One would think that many individuals who are convicted feel that they shouldn't be there, that it's unfair that they're there. But when we get to factual innocence, and you touched on that in some of your commentary about some of the tools that are available now that were not available even 10 years ago, but certainly not 20, 30 years ago. What do you have any thoughts on that threshold? Because it is a threshold that's considerably lower than the current existing one, as well as in the United Kingdom.
For both prosecutors and defense lawyers, wrongful convictions is the worst thing that can happen. And so I agree with my friend from the Canadian Bar Association that the standard that the CBA recommends, I would applaud that and recommend that as well.
Okay, and for Ms. Kish, when you talk about a miscarriage of justice, how do you define that? Because we've heard very broad testimony from individuals at this committee. Some who want to look at almost painting the entire system with a certain brush and suggesting that there can be no rightful convictions under our system, and others who would say wrongful convictions should focus on people that are actually have not committed a crime, and in fact we should be out looking for the real perpetrator of the crime once that process is finished. In your view, and in the view of the Frye Society, what is the importance of factual innocence in deciding if a conviction should be overturned?
Thank you. That's an excellent question. We spend a lot of time in our organization speaking about wrongful convictions and over convictions, systemic discrimination, and of course all the broad societal factors that lead people into pathways of incarceration, where we believe that the viable alternative is a community response to whatever has happened. But speaking to this bill, in Bill C-40, we see a tremendous amount of women and gender diverse people. I mean, we're talking about a population with an average education level at the point of sentencing of grade 8. So people are very unaware of the legal processes that they're becoming swept up in. And we see this in combination with the conditions that people experience in pretrial incarceration, resulting in individuals just pleading guilty or at the base not understanding the processes that they're going through. So we see a lot of people who we believe are factually innocent, and then we see many more who we believe are over convicted and over incarcerated.
Okay, so on that issue of over convicted or over incarcerated, what precisely do you mean by that? Because this is something that we've heard from other witnesses. Are you suggesting that if a group is overrepresented, that an individual who's a member of that group, that should be grounds of finding that they've been wrongfully convicted, even if, in fact, they've committed the crime that they've been charged and convicted of?
More so, we see individuals who, perhaps in the example that was used earlier, would more factually be convicted of a lesser crime, but because of low legal literacy or improper, like not enough access to adequate counsel, because of systemic discrimination, they're receiving convictions that aren't proportionate to the experiences that they were engaged in.
Thank you. Thank you very much. Mr. Mendocino, please.
I want to thank all three of our panelists for their presentations and for their advocacy within the justice system. I think that one of the themes that has emerged from your remarks is that there is a profound need to ensure that we reduce, if we cannot entirely eradicate, miscarriages of justice and wrongful convictions. And certainly that is an ongoing responsibility that any officer of the court has and retains, especially members of the Crown Prosecution Service. I think as well the presenters identified the rationale which supports this bill, which is to really zero in on those cases where, for a variety of reasons, there may be circumstances that requires a harder look in detail. I was very alive to the concerns that were laid out by the panelists with regards to court delay, especially in the appellate system. Some of the developments around how we can unearth evidence which may have been previously available, developments around technology which help us better understand what is factual, provable evidence which can either support a conviction or an acquittal for that matter. The conditions of incarceration, which my colleague, Mr. Moore, probed a little bit, I do think are relevant in the sense that if a person has been wrongfully convicted, it demonstrates the life-altering and very negative consequences that can be visited upon someone unjustly. And then finally, the challenges which we've heard from our panelists today, as well as others, around systemic overrepresentation of racialized Canadians and Indigenous peoples. All of these are very good reasons why it's important to have this bill. I do want to ask in my remaining moments, and I'll ask any one of the three of you to chime in on this, whether or not, if we accept your amendments, there is a risk that we could be creating a parallel process which could be competing or at odds with the established routes of appeal. And I noted in particular, I think it was either Mr. Paisan or Wilberg, who talked about the different thresholds that merit an appellate review. And it sounds to me that the gist of the amendment that you are proposing is meant to kind of mitigate what you think is too high of a bar in the appellate courts by lowering the bar for consideration through this bill. And if I have misunderstood that, please feel free to clarify.
I'd be happy to address that.
Sure.
So what our proposal is with respect to the unsafe verdict is to introduce a new ground of appeal, not to lower any thresholds. This ground of appeal exists in the United Kingdom already. What it does is it fills a gap in our current appellate process. There is no ground of appeal that one can advance to determine whether a conviction is unsafe, separate and apart from legal errors that might exist. The only mechanism that exists is the unreasonable verdict ground of appeal, which is an exceptionally high threshold. So long as the verdict is one that could reasonably arise on the evidence, it is withstood on appeal. That means that there is a swath of cases where a judge at the Court of Appeal might feel that the conviction is unsafe, that they would have acquitted, but they can't intervene because a conviction is one of the reasonable
Okay, so can I just probe you on that, because I think we're getting to the nub of it. Ultimately, if we introduce this amendment, we are expanding the grounds of statutory appeal. And by doing so, in your own words, and having listened carefully to you, we are, in effect, creating a more flexible standard, right? That it would encompass potentially a greater subset of cases that are not currently captured by the law. Is that a fair summary of your...
I don't want to wordsmith with you, member, but I see it as being more flexible. Right? The idea that the Court of Appeal, we must recognize that for 99.9% of cases, the Court of Appeal is the forum of last resort. That's the forum that should be equipped with the most tools to rectify wrongful convictions. And we say a more flexible approach with an unsafe verdict ground affords those tools.
I think we're in agreement on that, because that was the word that I used, flexible. Yeah, but yeah. If we were to introduce that, is it your opinion that by doing that under the existing statutory rights of appeal, that we would potentially be shrinking the subset of cases that may go to the special review process that might lead to a review of wrongful convictions? I'm just trying to understand the gist of it. Have I got it right?
Yes, you do. So in effect, you're front-loading catching the wrongful convictions, which would mean that it's a faster process, it's a more fair process, and one that doesn't utilize this special process that is after the fact. So what you're in fact doing is empowering the Court of Appeal to catch wrongful convictions before they languish for years in the post-conviction review state.
Okay, I may pick up on a second round if I've got time. Thanks very much.
Thank you. Monsieur Fortin, pour 6 minutes.
You have 6 minutes. Thank you, Chair. I would also like to start by thanking the witnesses who are here with us today. Your participation is important and will help us take better decisions. I'm also concerned about the threshold that varies. We are now going from an error that may have been committed to one that could have been committed. So we should have recommendations on improvements. I'm afraid that this could overburden the justice system. But let me come back to one issue. Right now, there's provision for 5 to 9 commissioners, whereas the report talked about 9 to 11 commissioners. 5 to 9 commissioners. According to some witnesses, this is concerning when it comes to the possibility of properly functioning. I would like to know what you think about it. Would it really be preferable to have a bigger commission that includes more commissioners, maybe promote diversity as well, with a bigger panel? Maybe Madam Kish should start, and then Mr. Weiberg and Mr. Paisena could answer the same question. Madam Kish, you may start.
Thank you for your question. I was just reflecting that while I don't have the expertise to understand how the dynamics of having a specific number of members would unfold, what we really want to get at is to see the commission be able to reduce what is right now an egregious amount of timeline to get your app. I mean, for those people who can get to a 696 application, having no timeline for the minister review. And it can take individuals years to get to an appeal. As I was saying in my comments, many people are discouraged upon conviction from appealing. They're told they don't have the ground, so they abandon their efforts to appeal. It might take 5 or 10 years until new evidence surfaces. So what we really want to see is timelines, just legislated systems of accountability, so that however the commission unfolds, it can be measured and augmented over time to be the most responsive that it can be.
Merci, Monsieur Weiberg.
Thank you, Mr. Weiberg.
Thank you. I would agree. The important thing is that it can be done as quickly as possible. The British Columbia case that was referred by the minister I mentioned earlier this year, last year, came about as in a change in science in terms of hypothermia and drowning. And the individual had been ordered to serve life with no parole for 25 years. So as soon as that report came out and the Innocence Project looked and thought, this probably is a manslaughter, not a first-degree murder, the sooner that could be dealt with, the better, in my opinion.
Le plus tôt sera le mieux, j'en conviens, mais...
The sooner the better, I agree. Is it preferable for us to have a commissioner with 9 to 11 commissioners according to C40? Should we have one with 9 to 11 or 5 to 9? A bigger commission?
I'm afraid I'm not an expert at that. I go to court and run trials now as a defense lawyer all the time as a Crown. The number of commissioners, I have to confess, I'm not an expert on that, so I won't guess.
Merci, Monsieur Wiberg.
Thank you, Mr. Wiberg. Mr. Paisana, any opinion on the matter?
In my opinion, what's far more important is the designation in 696.74 of them being potentially part-time commissioners. I'm much more concerned about the fact that they're part-time as the number. I'd like to see full-time commissioners. I think that shows the dedication necessary for this project. I think that will much easier withstand the caseload that will come into play. And I think that is the far more serious consideration as opposed to the difference between 9 or 11, whether they're full-time or part-time, I think is the much more significant issue.
Merci, Monsieur Paisana.
Thank you, Mr. Paisana. On the same topic, we know that right now, applications for review could take up to between 20 months and 6 years, and that's enormous as a deadline. What C40 is proposing, I'm not sure it's going to reduce the timelines, maybe increase the timelines, especially if we consider that people will have to prove that a miscarriage may have been committed. So what do you think about the delays or the timelines? Should the maximum timelines for reviewing such files or do the 20 months to 6 years appear reasonable for you?
The current status quo is not reasonable. It's the main impetus behind the push for this legislation. In my view, a legislative timeline is something that could be considered. I think the difficulty with that is that no case fits any sort of particular criteria. Some may take longer than others. I think the much more significant push should be for resourcing and funding. The bill is a very general structure of how decision-making will take place. It does not actually set out how the process of the commission will work. That's being left for policy and funding. That's the key question that will determine the flexibility and speed with which this organization confronts the problem. If it is underfunded, you're certainly going to have worse problems. If it is properly funded, I have confidence, whether it's 9 commissioners or 11, that the process will actually increase efficiency. It's just that question of funding is not something that can be addressed at this stage, but when it is addressed, it is vital that proper funding is dedicated to this process. Okay. And you heard of a witness on the 23rd that talked about it.
Thank you very much. Mr. Garrison.
Thank you very much, Madam Chair, and thank you to all the witnesses for appearing today. I'd like to go back to Ms. Kish on the question of over-conviction and over-sentencing. And when you read through the bill, the text of this bill, I wonder whether you feel that it's clear that the question of sentencing is a question of miscarriage of justice or not.
That didn't strike me as a salient aspect of the legislation, no.
And so what you're telling us is that with the clients that you work with, that quite often it's not guilt or innocence, but the application of the proper statute, a conviction of the proper statute, and the assignment of a proper sentence that constitutes, or the failure to do that constitutes a miscarriage of justice.
I think we really see like 3 dominant experiences, and one are factual wrong convictions at the serious offense level, so especially for life sentenced women and gender diverse people. and then individuals, especially perhaps related to Party 2 convictions, where the grounds for conviction we would consider to be very shaky, and then a host of individuals who plead guilty to lesser offenses and who have very low literacy and legal literacy and simply accept charges or accept convictions to get out as quickly as possible. And so in the former two that I just shared, I think these we would constitute as people being overly convicted, people receiving life sentences for being present, whereas if they had had adequate counsel, they would have been exonerated or receiving perhaps an involuntary manslaughter conviction.
And do you think the creation of this new commission will address the problems that those who are serving sentences have in getting review of their convictions?
We put forward, and I'm sorry for the timing that it just came through today, but we put forward a bill that really speaks to what happens post-conviction, and we encourage consequential amendments to the CCRA because the agencies regulated by it, the Correctional Service of Canada and the Parole Board of Canada, are right now so heavily reliant on considerations of level of responsibility. We see individuals having very, very strong legitimate reasons to abandon innocence claims and navigate the system to access parole and access the reintegrative services in prisons. So we think that this is an amendment that could greatly strengthen the bill and help because, sorry to go on, but institutionalization and community reentry supports are a priority of this bill. And we worry that those priorities won't be meaningful if not in consideration of the system of incarceration.
And so how do you see in that recommendation the relationship between the commission and other statutory boards like the Parole Board or under the Corrections Act? Do you see the commission as having power to direct or giving advice, or what would you see that relationship as?
Thank you for the question. We recommended an amendment which would give powers to employees, commission members to provide general direction and guidance to agencies regulated by the CCRA. As there is a mandate for employees to reach out to applicants and potential applicants and provide education and awareness, we want to ensure that people in prison aren't afraid to do so and that prison employees and administrators are educated and up to speed on the risks of wrongful convictions. So we do dream for a consequential amendment to the CCRA that expressly prohibits punishment of people for seeking redress, but then we say at minimum powers to provide direction and education would be wonderful.
And how often would you say that you do, I know you apologize for going on, but I think you're raising a very important point here. How often do you see this affecting clients that you're working with in the system where they're denied access to program because they maintain their innocence?
In most instances. So we work very hard. We work closely with the Correctional Service of Canada and the Parole Board to raise awareness. And certainly at the senior level, there are knowledges of legislative and constitutional requirements. But when you get to the decision makers, the people writing the A4Ds and granting or denying incarcerated people access to programs, that's where the public education and the direction is really needed.
And do you feel that those who are denying those feel that they are following the letter of the legislation when they do so?
Yeah, if you look just at CSC policies or the Parole Board decision-making framework, I mean, the PBC framework is less reliant on it. Just about all Correctional Service of Canada decisions are very reliant on level accountability. So this would be the agency we would prioritize. And yes, I do believe that they're just following their policy direction.
Great. Thank you, Madam Chair. Do I have any time remaining? Okay. I think I heard from all of you support for removing or modifying the requirement that appeals be exhausted. Would it, in your opinion, maybe I'll go to Mr. Paisana here, would it be sufficient to create an exception so that the Commission could examine cases which hadn't been appealed, rather than creating a general, or removing that requirement altogether?
30 seconds.
Yeah. So our answer to the question lies already in the legislation. So if you look at 696.4 sub 4, it shows that there's an exception built in for those who haven't appealed to the Supreme Court of Canada. All we're suggesting is you just expand that to include those who haven't appealed to the Court of Appeal. So you're already contemplating doing this. It's just extending it to an analogous situation.
Thank you very much. We will now move to our second round, and we're going to commence with 2 4 minutes each, and we'll start with Mr. Van Popta.
Thank you to all the witnesses. Mr. Pezana, you heard Mr. Weiberg in his opening remarks highlights some substantial changes to criminal law procedure, including changes to rules of disclosure, the Stinchcombe case I think you referred to, and also advanced scientific tools around DNA evidence. Now, in your opinion, will there be fewer wrongful convictions now with these new rules and new procedures? And I would note that David Milgaard never would have been convicted if we had DNA technology in 1970 that we had 30 years later.
So in my view, I'm a proud Canadian lawyer. I'm very proud of our justice system. But the vigilance that's required to prevent wrongful convictions should never subside. It's the institutional resistance to the acceptance of the idea of a wrongful conviction that breeds wrongful convictions. For many years, we thought microscopy was a very valid science that could give us those same kind of assurances, and it turned out that we were wrong. Today, even DNA is being questioned in some circumstances, depending on the sensitivity of the technology and the kind of match that's being developed. That vigilance is extremely important. Though I am proud to be a Canadian lawyer in our system, we have to be ever vigilant that our processes don't suffer from that. I don't want to call it arrogance, but overconfidence.
I'm just going to jump in there. I wasn't suggesting that we lower our guard at all, but my question was whether factually there will be fewer wrongful convictions with new rules around evidence.
Well, that's the hope, is that that's the case. It's impossible to tell because there's also going to be an increase in wrongful convictions with the increase of those technologies in the sense that we'll be able to expose them more. In addition, the false guilty plea phenomenon is one that we are very much new to, and we expect that there will be a great deal of wrongful convictions that will be uncovered through that process. So though I am optimistic that those technologies and advances will prevent more wrongful convictions, I am not in a position to say that we're any better off without more vigilance.
Thank you. I'm just going to pivot now. You gave testimony in front of the Laforme Westmoreland Commission a couple of years ago, and you're quoted at page 103 as stating, and I'm paraphrasing, that you simply do not believe that everyone in prison will claim that they were wrongfully convicted. Now, we put a similar question to Mr. Curtis of the UK Commission, and I asked him what they do to ensure that the application intake system doesn't get clogged with what I call faint hope applications.
I think it's a valid concern to make sure that the floodgates don't open and don't overwhelm the system at the risk of obscuring those that truly need it. In my experience working in the prison system, most individuals who have been there for a long time have come to terms with that reality. The people who seem to access these resources are the ones that are truly of the view that they are innocent. And to a point, and this speaks to something Ms. Kish was saying earlier, we've had many people at the Innocence Project who have gone well beyond their parole ineligibility period, who maintain their innocence even though they were eligible for parole years earlier. And the main impediment to get them getting parole is admitting their guilt. People that spend 10 and 15 years longer than their sentence because of that.
So I understand that. Now, Mr. Curtis said that only 3% are actually successful. He said 97% are disappointed. And that's when I asked him about the intake process to make sure it doesn't get clogged up. So what do you think about that? 3%, 97%, is that sort of what you would expect to be the ratio?
It's impossible to tell because of the outreach challenge that we have at this stage. This is a new system. How well it will be rolled out in prisons to people that will be aware of it and how they apply will be I think the driving force to how difficult of a problem it will be to weed out the poor applications. I think an intake screening process is necessary. And the one in Bill C-40 I think is fairly robust. There are a number of criteria here that you see that should serve the tool of screening out some of those applications.
Thank you. Thank you very much. Madame Brière.
Merci, Madame la Présidente.
Thank you, Chair. I would like to thank all the witnesses for coming here this afternoon. My question goes to Mr. Paisana. The bill provides that once the analysis is completed, the Commission will take a decision when it has reasonable grounds to conclude that a miscarriage of justice could have occurred and feels that it would serve the interest of justice. So I'm wondering about the need for adding this criterion about the interest of justice. don't you think it could disadvantage some marginalized segments of the population?
I agree if the viewpoint is looking at that requirement in a way that is restrictive, which I think is one possible interpretation of that. The other way of looking at it, and this is somewhat hinted at in the bill, is the idea that you may have a case that's on the fence, but the interests of justice pushes it over the fence in consideration of things like distinct challenges of the applicant, the personal circumstances of the applicant. So I actually think it can work both ways. To the extent that you have a case that might be a wrongful conviction, but for some reason the public interest suggests it shouldn't be reviewed, I agree with you. That seems inconsistent with the spirit of the bill. That may be something that's left to the interpretation of the bill down the road, but it seems to me that interests of justice in no way could override the fact that there may be reasonable grounds to conclude a miscarriage of justice occurred.
Dans quelles circonstances?
Under what circumstances, therefore, could this not be in the interest of justice?
That's the part I'm struggling with, is this idea that it could ever be contrary to the interest of justice to review a conviction that there was reasonable grounds to conclude may be a miscarriage of justice. And that's why I think in the power of, when we look at statutes and statutory interpretation, it's within the scheme of the whole bill. I think the more likely interpretation that would be brought to bear to this requirement, if it remained in, is the one that I said earlier, which is that it actually should be a positive attribute to an application as opposed to a negative, if that makes sense.
Merci beaucoup.
Thank you. In paragraph 696.5, the two criteria are mentioned as alternatives. It stated that the Commission may carry out investigations if there's reasonable ground to believe that there could have been a miscarriage of justice, or if it feels that this could serve the interest of justice. My question is, should the power to investigate be mandatory, or should it be must investigate? Why were the two criteria stated as alternatives?
So I'll break down your question into two. I agree with you. It should be must investigate, not may. I'm not sure why there is a discretionary feature to this. Like the whole point of the standard is to reach a standard such that a power is triggered. With respect to the disjunctive routes, I think it makes sense that there be a disjunctive route at this stage of the process, because there can be cases where it's in the interest of justice to review it, where on the face of it, it may not appear to be a miscarriage of justice. And this comes back to what we call the catch-22 in post-conviction review. Post-conviction review often relies on new matters of significance, but persons in custody don't have the ability to investigate those matters of significance. So there may be an aspect of the case that cries out for a response, but you can't reach the threshold of reasonable grounds to believe because you don't have access to the investigative powers. But through the process of the interest of justice avenue to get to the investigation, you can access those resources such that you might eventually get to the point with new matters of significance that achieves the ultimate result. So it's a separate avenue that I perceive to be valuable for those that are in the catch-22, as we've called it, in post-conviction.
Thank you very much.
Thank you very much.
Monsieur Fortin, pour 2 minutes, s'il vous plaît.
Merci, Madame.
Thank you, Chair. My question goes to Mr. Paisana. I would like to hear about I would like to hear what you think about exhausting the rights of appeal. We hear that the appellant must have exhausted all avenues of appeal before asking for a review. So I would like to know what you think. I have just 2 minutes, so maybe I have a minute and a half left, so I'll give it up to you.
So we are very much of the view that this, as a mandatory requirement, it should be removed. And the reason for that is that the appellate process is very cumbersome, and it requires a great deal of sophistication and expertise. So to give you a sense of how it works, when a person appeals, they have to file a notice of appeal, they have to order transcripts for the hearing that are relevant, and then they have to file a factum. The Crown needs to respond, and then there's a hearing before 3 judges of the Court of Appeal. That process, on the best case scenario, usually happens within a year. That process often requires legal aid support if the person is unsophisticated and in custody. Legal aid has its own criteria for merit, and there may be many cases where legal aid is not prepared to fund something if there is no merit on the face of what the accused person can muster in terms of grounds of appeal. And therefore, you're setting up a situation where people, particularly those who have falsely pled guilty, will see significant barriers to interceding at the appellate level, such that they will be completely discouraged from doing that or not know how to do that, and you won't be able to access the commission after the fact because you haven't done that step.
Merci, Monsieur Paisana. En quelques secondes.
Thank you, Mr. Paisana. Don't you think that if we eliminate this requirement, the commission will be overburdened, people will be turning to a review process instead of asking for an appeal, instead of filing appeals?
So what I'll direct you to is this seems to be contemplated in the legislation. So if you look at one of the factors that's relevant to acceptance and the ultimate decision, under 696.65C, the application is not intended to serve as a further appeal. And I would suggest that that would include an appeal in first instance. And so it should be a relevant factor that the person has not appealed. It should be weighed in the analysis. All we're saying is it shouldn't be determinative. There will be cases where it will be appropriate to not force the person to go through the appellate process.
Thank you. And for our final round of question, Mr. Garrison, please.
Given they have only 2 minutes, I'm going to focus on a couple of things I think are not in the bill. And we've talked about sometimes that miscarriage of justice are the result of systemic factors. And there doesn't seem to be anything in the bill that would allow the Commission to recommend to the Law Reform Commission, to Parliament, or anyone a way of addressing those factors. And the second one is if in the process of investigating a miscarriage of justice, the Commission finds dereliction of duty, malice, or other professional misconduct, they don't have the power to refer that to anyone. So I'm going to ask the Canadian Bar Association, Mr. Paisana, quickly on those 2 points.
So with respect to law reform, we do support the idea that the Commission should refer and participate in law reform projects. They are uniquely positioned to see the wide spectrum of wrongful conviction issues that come before them, and they're uniquely positioned to study and provide data and input with respect to those issues. With respect to the referral of misconduct, this is something that came up in the consultation phase. We're of the view that there are plenty of ways in which misconduct can be reported. The Commission doesn't need to be the avenue through which that occurs. It can be something that they raise within their decision-making process. That is, that this is something that a particular group or body or regulator should consider, but they don't have to be the actual source of the referral. There are plenty of other watchdogs, if I could put it that way.
Thank you. In the 30 seconds remaining, Ms. Gish, maybe you can comment on these two.
Sorry, I was having a hard time unmuting myself. Yeah, we think that with all of the amazing evidence and insights from impacted stakeholders and wrongfully convicted people that went into the beautiful report from the Commission, that there should be every opportunity to address systemic cultures of miscarriages of justice, because certainly they exist. I mean, you see it in the outcomes. Half of people in prisons for women being Indigenous doesn't demonstrate that Indigenous people are more deviant. It demonstrates that there are flaws in our justice system. And we want our system to be as responsive as it can be, as Tony indicated, to provide just and fair outcomes for everyone. So every opportunity we can clearly legislate relief, we should do so.
Thank you. Thank you very much to all our witnesses for appearing this afternoon, and thank you to colleagues. Let's suspend for 2 minutes to allow our next panelists to be tested if they're virtual, or I think we have one in person. For the second hour, we're going to continue our study of Bill C-40. With us today, we have two witnesses, one in person. Good afternoon, Madame Catherine Campbell, appearing as an individual professor, criminology, Faculty of Social Sciences, University of Ottawa, as well as on the screen we have Madame Lindsay Guise Smith, Directrice Executive, North Carolina Innocence Inquiry Commission. Yes, Mr. Moore.
Yes, did you want me to move my motion?
Go for it.
I don't want to take any time from the witnesses, but quickly, there was a notice of motion that I think that's been circulated that we have the minister appear before the committee to discuss the supplementary estimates sometime up to and included as soon as possible, but no later than December 7th. There seems to be consent for that, so that's great. This is the motion. Agreed? Yeah.
Thank you, Mr. Moore.
Thank you, Chair.
That's how I like things to be done, very efficiently. Thank you very much. Okay, so fabulous. The witness on the screen has been tested, and the equipment is working well. I will ask each of you to commence with your remarks up to 5 minutes each, and we will start with Madame Smith. Floor is yours for 5 minutes.
Thank you, Madam Chair. The North Carolina Innocence Inquiry Commission is the United States' first and only independent state agency charged with the neutral investigation of post-conviction claims of factual innocence. The preamble to the legislation that created the Innocence Inquiry Commission in 2006 states, whereas post-conviction review of credible claims of factual innocence, supported by verifiable evidence not previously presented at trial or at a hearing granted through post-conviction relief, should be addressed expeditiously to ensure the innocent as well as the guilty receive justice. And whereas public confidence in the justice system is strengthened by thorough and timely inquiry into claims of factual innocence, and whereas claims of factual innocence, which are determined to be credible, can most effectively and efficiently be evaluated through complete and independent investigation and review of the same. This preamble encompasses the Commission's mission. Although wrongful convictions erode public confidence in the criminal justice system, addressing them enables criminal justice stakeholders to learn how to better ensure justice is served. For every wrongful conviction, there is a true perpetrator at large, a victim under the false impression of having received justice, and an innocent person that may spend years in prison for a crime they did not commit. Accordingly, the Commission is designed to uncover the truth from a neutral perspective outside of the adversarial criminal justice system. By design, the North Carolina General Assembly limited the scope of the Commission's work, while also granting the Commission very broad statutory authority to achieve its mission. There are 3 hallmarks of the Commission process that make it successful. First is this broad statutory authority. The Commission is given all of the authority of both the rules of criminal procedure and the rules of civil procedure in North Carolina to ensure that we can achieve our goal of uncovering the truth in claims of factual innocence. This has resulted in the Commission being able to review and interview and depose individuals who had not previously participated in a case, having access to files and evidence that others may not have been able to access, and the Commission locating physical evidence that agencies had claimed did not exist or could not be located, among other things. In fact, the Commission has located physical evidence in 28 cases where others said it no longer existed, including in 12 of our 15 cases where individuals were ultimately exonerated. Second is our neutrality. Because we do not enter into any kind of attorney-client relationship with the claimant and are not working on the claimant's behalf or even on the behalf of the prosecution, we can be curious in our endeavor to find the truth. This allows the Commission staff to ask necessary but difficult questions as part of our investigations. Because claimants have to waive all of their constitutional rights to participate in the Commission process, and can do so because our process is narrowly limited to claims of factual innocence, many of the concerns that attorneys face in an adversarial system simply are not factors in investigations of these claims. Our neutrality also shapes how we measure success. A good day at the Commission isn't based on whether a claim results in an exoneration, but rather in whether we are able to fully investigate a claim and provide answers that the criminal justice system didn't previously have. The third hallmark is confidentiality. By statute, the claims we investigate and the investigations themselves are confidential during the investigation, and only in certain circumstances is information released to the public about cases. This allows the Commission to develop rapport with witnesses, to have full and frank conversations with witnesses, law enforcement agencies, and others involved in cases, and often leads to positive change within the criminal justice system. We have especially seen this with respect to changes in evidence storage and handling at law enforcement agencies throughout North Carolina. Since its creation in 2006, the Commission has received 3,571 claims. We've received 194 claims thus far in 2023, putting us on track to receive 233 claims in 2023, up from our average of 211 claims per year. We have held 19 hearings since our creation, and will hold our 20th hearing next week. 15 individuals have been exonerated by a post-commission 3-judge panel or had their convictions vacated through a motion for appropriate relief and have been granted a pardon of innocence by the governor of North Carolina based on the Commission's investigation of their claim. Additionally, we have definitively confirmed guilt through DNA testing in 13 cases.
Ms. Smith, why don't I have you continue with the questioning? You'll have lots of time when you're asked questions. We only have 2 witnesses for the second hour, so there should be plenty of time. Ms. Campbell, for 5 minutes, please.
Thank you. First of all, I want to thank you very much for the invitation to be here today. It's a real honor. As an academic, I've published extensively in the area of miscarriages of justice in Canada and other common law countries for the last 20 years. My research is focused on a number of areas, including examining the factors that contribute to miscarriages of justice and prison and post-release experiences of the wrongly convicted, amongst many other things. I also took part in the consultations held by Justices Lafforme and Westmoreland-Traore around the proposed reform in 2021. And I've met, spoken to, and interviewed many wrongly convicted people over the years, and I'm well aware of the devastation that a wrongful conviction can wreak on individuals and their families. In 2021, I started Innocence Ottawa, which is through the Department of Criminology an Innocence project that's run by criminology and law students, and our aim is to help the wrongly convicted who are seeking exoneration. Now, we've come a long way, as when we started in 2012, we had bake sales and sold T-shirts to fund our work, whereas in 2023, we just received an Access to Justice grant from the Ontario Law Foundation for an outreach to Indigenous prisoners program, so we've really moved quite far. And it's clear, and I've heard this through these hearings these past few weeks, and I think we all accept that Indigenous and Black prisoners are overrepresented in federal and provincial and territorial institutions, but they're strangely absent in the numbers of exonerees or even amongst the numbers seeking conviction review. And thus far, Innocence Ottawa has filed 1 application for conviction review through the CCRG on behalf of one of our applicants. So I'm well aware of the difficulties in the current system. system. In fact, we submitted his application in 2019, and in 4 years later, it's still at the preliminary investigation stage. And just as an aside, he also happens to be a person of color. So my frustration over the last 20 years of the difficulties and challenges of innocence work is that it just shouldn't be this hard to overturn a conviction, to correct an error, because the stakes are just too high. So thus, I greatly anticipated the new legislation, and I feel it's a very important first step. And now, in the next half of my short talk, I'll briefly comment on what I see are the strengths of the bill, and then the areas that I believe are in need of improvement. Now, the independence of the conviction review process now, I think, is an excellent step forward, but I feel that there are some constraints on this as well. The commissioners should not be considered as government employees. The commission itself, I believe, should be viewed more as a court rather than a small government agency, and it should be located outside of Ottawa with possible regional offices. Otherwise, that may detract from its perception of it as being independent. Accessibility. The bill proposes to enhance access to previously marginalized groups, those who are overrepresented in the criminal justice system, particularly Indigenous and Black prisoners. And I think being an altogether new entity may help address this matter with a new conviction. The change in the threshold test, I think this change from, as has been discussed in the previous hour I was listening to, from a miscarriage of justice likely occurred to a miscarriage of justice may have occurred, or if the commission considers it's in the interest of justice to do so, then they can conduct an investigation. I think that's an important step, and it sounds far more expensive. At the same time, though, I wonder to what extent this is going to change things, because as it also is somewhat vague, and in my experience thus far with the CCRG itself, Criminal Conviction Review Group, is that it's unclear as to what it actually takes to recommend reviewing a conviction. 3 other important additions: examination of personal circumstances of an application, enhancing investigative powers, and greater victim involvement are all really important additions. Areas in need of improvement: the number of commissioners, I believe, is far too low. The Lafleur and Westmoreland Traore report advocated for 9 to 11 commissioners. That seems reasonable and necessary in my view. The number suggested by Bill C-40 is clearly not adequate, because if the commission isn't properly staffed with both commissioners and investigators, it's going to incur huge delays, and that's an ongoing issue with the CCRG. I can't read that, sorry. 30 seconds. A couple other things. The mandate, I believe, should include sentences. A sentence can also represent a miscarriage of justice. And also those whose cases have not yet been before a court of appeal. Otherwise, it may severely limit the number of applicants. And finally, I think as an academic, we have a really great opportunity here with this new commission to get it right, to have a proactive and systemic approach to miscarriages of justice, to collect data from cases, derive policy lessons, discern patterns. I think it would be a shame to miss that opportunity with this new commission. Thank you very much.
Thank you very much to both of you. We will now commence with first round of 6 minutes each, and we will start with Mr. Van Popta.
Thank you, Madam Chair, and thank you to the witnesses. Thank you, Ms. Smith, for coming here all the way from North Carolina and sharing your experience over many years. We're just starting this process. My first question is about the intake process. Now, in your testimony, in your opening remarks, you quoted some sections of the legislation, whereas post-conviction review of credible claims of factual evidence, that would be number 1, supported by verifiable evidence. Number 2, and not previously available at trial. Number 3. So how does a person get over that first hurdle of having their application heard by your commission?
Sure. So I want to make clear it's not previously presented at trial. So it could have been available, but it can't have been presented at trial. So that is one factor. So when they apply to the commission, they can tell us what is new, but it is not necessary for them to always know what is new. we don't put that burden on the convicted person, the claimant, to necessarily, let's say, for instance, know that there is definitively DNA or evidence that hasn't been DNA tested in their case. We will do the work to figure that out. But we ask them, they fill out a 22-page questionnaire, give us as much information as you can about your case. You know, what is your innocence claim? And then we begin the process of figuring out, is there something here that can be done? Is there something new? And so we may go back and look at a trial transcript to figure out what was presented at trial. We'll assess whether there is forensic testing that hasn't been done or could be done. Or they may come to us and say, hey, there's a new witness that has come forward that is saying something that was never presented at trial, or there's a witness that has come forward and changed their story. And then it's a question for us of assessing the credibility of that witness. Are there other factors that make that person credible? Is there other evidence out there that would make that person credible?
Good, thank you. Now, your commission has broad investigative powers. What do you do with that evidence that you gather? Is it then presented to court if you deem this to be a successful review?
So we have it's a kind of a two-step process, or maybe three-step process. Our staff, we are a state agency. Our staff are state employees. They do the day-to-day operations. Once there is some credible, verifiable evidence of innocence, it's in the director's discretion as to whether that case moves forward to a hearing. If it moves forward to a hearing, that is heard by our commissioners. The commissioners are appointed by our Supreme Court Chief Justice and our Court of Appeals Chief Judge. And they are members from, different areas of the criminal justice system, a judge, a prosecutor, criminal defense attorney, sheriff, victim advocate, and some others. They hear the cases, and if they determine that there is sufficient evidence of factual innocence to merit judicial review, then they'll move the case forward to a 3-judge panel. That 3-judge panel then hears the case and makes a final determination as to whether the convicted person has proven by clear and convincing evidence that they are in fact innocent.
And all the evidence that you gather then is presented to this 3-person tribunal, including perhaps self-incriminatory evidence?
So when we are presenting the case to the commissioners, all relevant evidence is presented. All parts of it, the good, the bad, the ugly. It's non-adversarial. When it goes to the 3-judge panel, it becomes adversarial, and the parties get to present what works for them. So they may present it in the light most favorable to their client, and it looks a little bit different than it does before our commissioners. But the state, of course, is represented by the prosecution, and they may present things that are unfavorable to the convicted person. And of course, the convicted person can present all of the things that are favorable to them.
Good, thank you. Now, you or somebody from your commission gave evidence at our Laforme Westmoreland Commission looking into the miscarriages of justice. And I'm quoting here from page 14, I think it is. And this is what they concluded about your evidence. Some of your evidence, sorry. We considered a test that would allow the commission to refer cases back to the courts on factual innocence grounds, as used in North Carolina. We ultimately rejected such a test on the basis that it was too restrictive. That's here in Canada. We're taking a different direction with this draft legislation. So, what are your comments about it? Why was this important in North Carolina?
I think in North Carolina it was a balance, a policy decision that they wanted to limit the scope to factual innocence claims, and in order for this process to work in North Carolina, it needed to be limited in that manner. And I can't really provide an opinion as to what Canada should do or what standard you all should put into place, but can really only speak to what we've chosen here in North Carolina and how we've seen success in the model that we have chosen here.
Good, thank you.
Thank you very much.
Thank you so much.
Thank you so much. Mr. Housefather, please.
Thank you very much, and thank you very much to both witnesses. I want to start with a question of something that's preoccupying me with respect to the legislation, which is the prerequisite that people need to have exhausted their appeals process before they can make use of this legislation. And so I'd like to ask both witnesses, I understand first in the North Carolina context that is not a requirement. People need not have exhausted their appeals processes if they can, by the preponderance of evidence, show you that they are actually innocent and provide factual evidence of innocence. Is that correct?
That's correct.
Perfect. And can I ask perhaps your opinion, Professor, about that and whether or not that should be changed in the draft bill?
Well, I would say in terms, we get about 30 to 50 applications a year. And we have our criteria that they have to meet. And one of those is they have to have exhausted all their appeals. And that eliminates probably half of them right there. And I think the process is so lengthy anyway. This may, with the having the bill, I mean, I understand that that's still there in the bill, whereas there may be special consideration for certain cases, perhaps as the last paisano, the witness gave in the just before this hearing. Perhaps that may be a way to go about it, having it as an exceptional case that you would be allowed to go ahead despite having not done that yet.
Right. Because my concern is essentially that the poorest defendants, the defendants that are the most likely to wind up in the system, are the least likely to have the means to exhaust their appeals. So if this is really meant to deal with the disproportionate number of Indigenous and Black incarcerated people in our systems, or poorer people, we're in a situation where they would be the least likely to have exhausted their appeals.
Absolutely. Absolutely. And I think if I can just make a comment on this point as well, it's related to it. I don't think a lot of people know about the conviction review process at all. I met with an elder this week on our Indigenous outreach program, and that was what he said to me. He said they don't even know about it. They know what an appeal is. They get that because they have a conviction, but that's it. And so I think we really need to be better at reaching people, and one way would be what you've suggested, and also just information.
And just, Professor, the UK legislation, for example, has that exceptional circumstance where they can decide to not require all the appeals to be exhausted. Have you looked at what it says in the UK legislation? Would you recommend something like that?
I would. I mean, I've written about the CCRC as a model for us with Professor Clive Walker. I've written a couple of things about that as a model for us here. But I think one of the biggest issues was not that, but was the whole idea of funding and have it to be adequately funded, because there's huge problems there now with their commission, given that they just don't have enough money.
Thank you. And coming back to North Carolina again, and very interested in this model as well. The 8 commissioners that are named by the 2 different judges of the court, they represent different criteria, right? One of them represents sheriffs, and one of them represents the public at large. Is there any? There's been requests in the commission here for members of minority communities to be represented on the panel of people. Is that a requirement in North Carolina at all?
So as part of the statute, it requires that the Chief Justice and the Chief Judge consider diversity, both in gender, racial makeup, and in geographic diversity of the state. And so when we send the appointment information to the Chief Justice and the Chief Judge, that's something I always let them know is kind of what the current makeup of the commissioners is and who's leaving, and so that they kind of have an idea of where they might need to go.
3 justices that will hear, because as I understand it, the commission will refer cases where they have determined that by preponderance of evidence the person is innocent to a 3-judge panel. Is that a special 3-judge panel? Is it of the North Carolina Supreme Court? Who are the judges on it?
So the judges are Superior Court judges. In North Carolina, that's our felony trial court judges. And they can come from anywhere in the state. They just can't have had anything to do with the original case. So they can't have been involved in the original trial or plea or any post-conviction work on the case.
Are there any instances, for example, where the case will stop by the commission's decision, for example, that the prosecution, at that point, the North Carolina prosecutor will say, I agree with what the commission has found. I'm going to either drop it or I'm going to have them take an Alford plea and allow them to just end the case at that point?
Yeah, so we've had a couple of instances where the prosecution has agreed that the person is innocent, and they will join with the defense in asking the three-judge panel for the relief. That allows the convicted person to go ahead and receive the compensation from the state if they go that route. We have seen an increasing trend since 2021 of the prosecutors offering the Alford plea as opposed to going through the three-judge panel, and then defense counsel, consulting with their client as to whether to take the risk of going through the three-judge panel process. Or
Smith, she's put up the card, which means my time is over. So thank you very much. Thank you
You're
both
welcome.
of you.
A few more. That's fine. Monsieur Fortin, s'il vous plaît.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you, Ms. Campbell and Ms. Smith, for being with us today. Your testimonies are important. The topic is important. Ms. Smith, my colleague, Mr. Housefather, has just asked you one of the questions I had to ask you about the composition of your commission in North Carolina. Let me add, do you have any figures on the number of commissioners and where they come from when it comes to the issue of diversity, depending on the criteria that you use?
I don't have it in front of me, but I could look up. It's on our website, so I could quickly look up and tell you. If you give me just half a second, I can tell you.
Je vais vous laisser regarder. Je vais passer à votre...
I'll give you time to check that. In the meantime, I'll move on to Ms. Campbell. Good afternoon, Ms. Campbell. In your case, in your opinion, if on a file the commission finds that the judgment was the right one, but the sentence was too severe, in your opinion, is this a matter that the commission should consider as a miscarriage of justice and refer to the commission?
That I think the commission should consider sentence, because I think at times a sentence can be a miscarriage of justice as well. I mean, we've had people come to us with cases of, let's say, second degree when it should, in their opinion, it should have been manslaughter. But I mean, we're a small little innocent student-run project. We can't touch those cases. But is that a miscarriage of justice in that person's view? And maybe if you, in a broader sense of justice, it might be. So I believe that there's a place for sentencing to be reviewed in the new commission.
Et à votre avis, quel est...
And in your view, what should be the ideal timeline within which the commission should take a decision? Now it could go between 20 months to 6 years. Maybe it could be longer with the reform, maybe less. But what do you think about this?
In the real world, it would be a couple of years, I think. I mean, like the case that we have in front of the CCRG right now, we investigated it for 5 years. They've had it now for 4 years, and this man he had a second-degree murder sentence with release at 13 years, and so he's going in front of the parole board right now, right? So there's a dilemma attached to that as well. But I think that a delay of the thing that I think will help with the commission, the new commission, is that they will have access to all kinds of information that we never could get very easily, police records, Crown records, and that would allow for a more expeditious, I think, review of a conviction. So I think that 2-3 years at the most. I mean, the British Commission is very, very quick. I mean, if we could start to meet that standard, I think that would be really good.
Merci. Je reviens à vous, Madame Smith.
Thank you. Let me come back to you, Ms. Smith. Do you now have my answer on the statistics, on the number of commissioners, and where they come from?
Yes, sort of, roughly. So we actually have 8 commissioners and 8 alternate commissioners for each position. And the reason is because sometimes a commissioner is unavailable due to illness, or they need to be recused from a case if they had some involvement in the case, or if it's from the county where they are the judge or something like that. And so overall, we have 5 female commissioners and 11 male commissioners. We have 13 white commissioners and 3 black commissioners. And we have 5 commissioners from the western part of the state, about 6 or 7 from the central part of the state, and that leaves 3 or 4 from the eastern part of the state.
Et est-ce que vous êtes satisfait de cette composition?
Are you satisfied with this composition? Does it respond to the needs of the community in your view?
I always think that we can do better with diversity. And so I would love to see more diversity on the commission. And we always are mindful of that. When I am given the opportunity to make recommendations to the Chief Justice and Chief Judge for commissioners, I always include more diversity on that. And it's up to them as to whether or not they take those recommendations.
Et dites-moi, Madame Smith, est-ce que ces commissions...
Tell me, are they all full-time commissioners, or are these part-time positions?
So our staff are full-time employees. Our commissioner's role is just to hear cases. And so they hear cases only when we have those hearings. And we've had 2 hearings in 2023. And so that involves them coming to hear those cases for, 3 days or 4 days at a time, and then also participating in our commission meetings a couple times a year.
Il reste seulement quelques secondes.
I have a few seconds left. What is the average timeline for reaching a decision?
So our cases can vary. For an initial review, it takes a couple of weeks from the time we receive the questionnaire until we can review the case and decide whether there's any merit to the case. After that, it can take a couple of years to fully investigate a case.
Merci.
Thank you.
Thank you.
Mr. Garrison, please.
Thank you very much, Madam Chair, and thank you to both of our witnesses for being with us today. Professor Campbell, I want to return to the question that Mr. Fortin raised about whether sentences are subject to review by this commission. I don't see anything in the legislation that says they are not. And so I'm wondering whether it's an abundance of caution that you're suggesting that we explicitly add sentencing, because if I'm not mistaken, the current convictionary group has looked at sentences.
Well, they'll look at, they can look at dangerous offender designations and long-term offender sentencing designations as well. But perhaps it's, as you're saying, it's an overabundance of caution, because I suspect that once the commission is up and running, there's going to be, the floodgates will open, and there'll be a lot of people that will be asking for review. And I feel that there'll maybe be a need to be, I guess, to sort through what's more pressing cases. I don't know how that would happen. That certainly happened with the British Commission when it was first introduced. So I guess I feel that perhaps stating it explicitly would maybe make it happen.
Okay, because I had this question myself in reading legislation, trying to determine whether or not sentences were considered a miscarriage of justice. And I think maybe the way it's currently listed, that is left to the discretion of the commission. But that could, I understand your point, that could lead to different prioritization than if it was listed. I was very interested, and I think it's very apt, your comment about the strange absence of those who are most likely to need a review from the current process. So in terms of the new commission, do you feel there are adequate measures there to improve that record of review? Well,
there are statements to that effect, but I don't think there's legislative, I guess, pressure behind it. I mean, I've been listening to all of these hearings, and I know Justice Laforme was very disappointed in terms of wanting to have a mandated position for an Indigenous person and a Black person on the commission. And I don't really know how that would work legislatively, but I think it's one thing to say it, it's another thing to do it. And I think that could help in terms of access. And it is hard, because I think that people who are wrongly convicted don't have a lot of faith in the system as being legitimate. They made a big mistake in their case, they believe, and then to have to go back to that same system, which they do now, for review, I could understand why somebody would be reticent to do that. So I believe that there's going to have to be a lot of hard outreach work done. And I know there have been briefs that I've read for these hearings that are asking for just that. And it's going to have to be, it'll take some time, but there are steps. I mean, the fact that it is independent from government, I think is really, really important. And so that, I think, will help.
It's a frustration I think, often have in the Justice Committee in that we deal with the black letter law and not the budgets. And so if the commission is not adequately funded, then it won't be able to do that kind of outreach that you're talking about. In terms of legal representation for applicants, when we had the British Commission appear before us, they were saying that most of their applicants do not have assistance in filing applications. I guess, how do you feel about that in terms of the new commission and creating a process that wouldn't necessarily require legal representation to access the process?
That wouldn't necessarily? Yeah. I think that I don't think if somebody sitting in a jail cell is going to know what to do in terms of their application. They won't. And I know with the CCRG and my dealings with them over the years, they've told me their most fulsome applications come from innocence projects and people who have representation, which is very, very rare. I mean, there's a 3-year wait list at Innocence Canada for them to even look at your case, right? So it's tough. I think there is within the bill. I understand there is maybe that it would allow for legal representation in some instances, I believe, but I think I still think there'll be a role for innocence projects when this commission becomes a reality as well, because people will need support. It won't be easy.
And so I guess, have you looked at the bill in terms of leaving the space for advocacy groups to continue to work with applicants?
Well, I certainly saw that in La Forme and Westmoreland Traore's recommendations. It was right in there. I don't know if it's so explicit in the bill, though. I didn't really see that. And
I know you were able to hear the last session. I was asking about systemic factors. And I guess I'll ask you 2 questions there. First, in terms of your own experience, what have you seen as the main systemic factors in resulting in miscarriages of justice?
Poverty, I mean, is a big one for sure. Racism, lack of opportunity, lack of education, and not really understanding how the criminal justice system works. I don't think people the notion of what are your rights, right to silence, right to counsel, all of those things that we have, that we understand as being, something that every Canadian is entitled to. I think people don't necessarily understand that. Or when the police question you, let's say, that you have to answer what their questions, you don't, and people don't understand that.
Thank you.
Thank you very much. We will now move to our second round with Mr. Moore for 5 minutes.
Thank you, Madam Chair, and thank you to both of our witnesses for informing our discussion on this bill. Ms. Smith, you're in a very interesting, unique position as the only, I think you were saying, the only body like yours in the U.S. for North Carolina, and I've found your testimony to be very helpful. One of the things that I think we need to, when we're looking at this legislation, is to sort out is what Canadians' expectations are when we talk about wrongful conviction, we talk about when we talk about justice. And under your system, wrongful conviction, I think, is what most Canadians would expect when we talk about wrongful conviction, is that is a verifiable evidence of innocence. It means that, as was stated in your submission to us, that there is a perpetrator at large, that the accused didn't commit the crime. There's actually a perpetrator at large. There's a victim with a false sense of justice. And then, of course, you have someone who has been who is innocent and wrongfully convicted. That is not the case, however, with this legislation that introduces brand new factors such as the personal circumstances of the applicant, the distinct challenges that applicants who belong to certain populations face in obtaining a remedy for miscarriage of justice. So I think we need to live up to Canadians' expectations when we discuss this legislation. So you mentioned you had to work within the parameters of what North Carolina would accept. And in light of the fact that you're the only body like this in the U.S., why was it important that factual innocence be a part of your program?
That actually predates, me being at the commission. But looking back at the notes from the study commission, that was really just where the compromise was. So Chief Justice Lake was one of the former Chief Justices of the North Carolina Supreme Court. He brought together a group of folks from all across the different areas of the criminal justice system to talk about the causes of wrongful convictions and how we should address wrongful convictions in North Carolina. And in bringing together those various stakeholders, that was kind of where they landed. What were we going to do about wrongful convictions in North Carolina, and where should the focus be? And ultimately, they just decided that the focus should be on claims of factual innocence. They looked at what areas were our post-conviction appellate processes and our post-conviction motions for appropriate relief not able to address in North Carolina, and they felt like claims of factual innocence were the ones that were falling through the cracks, that those could not be handled very well in these other court processes, and that those were the ones that needed this extra attention and needed this extraordinary process with this extra broad statutory authority, this investigative power that we really don't see in any other process. I don't know really any other lawyer, at least in North Carolina, probably in the U.S., that has the authority of both criminal and civil procedure that can go out and get all of this information to try to get to the truth. It kind of is very different than the adversarial system that we're normally working in criminal law. And so when they were thinking about giving this much authority and this much power to an agency, they felt like that needed to be narrowly tailored to actual innocence.
Thank you. That makes perfect sense. I don't expect you to comment on our Canadian context right now. This bill further broadens the application of our wrongful conviction regime to a test that's, rather than saying a wrongful conviction likely occurred, to say one may have occurred, a miscarriage of justice. So we have to be very careful with as we draft this legislation. You mentioned in your remarks about victims, and what is the role of the victim in this, and is there concern about this process re-victimizing individuals? Is that a reason to have a narrower focus?
So hold that thought. Maybe you'll get a chance with another another questioner, or if we've missed anything and anybody would like to submit anything in writing to the committee, we would be happy to receive it. I will now move to Mr. Maloney for 5 minutes.
Thank you, Chair, and thank you to both witnesses, and I might get back to Mr. Moore's question in a moment. Ms. Smith, I'm going to start with you. I want to get some clarification on your process. You mentioned in your opening remarks, and you just said it again, that you're given all of the powers from the rules of criminal and civil procedure. I'm not entirely sure what that means in this context. And I also want to, maybe you can answer that and incorporate it into explaining to me, when your body goes through its process and reaches a conclusion, it then goes to a 3-judge panel. Is that right? And
yes, sir.
Okay, so when it goes to that 3-judge panel, what actually takes place there? Are they reviewing the work that you have done, or are they conducting another trial? Like, what's the process? What standard of review do they apply? Are the rules of evidence, for example, the same as they would be in a criminal trial at first instance or on appeal?
Okay, great. Lots to unpack. All right. So when I say we have all of the tools of criminal and civil procedure, I mean all of the tools. So we have the ability to get search warrants, just as law enforcement does, because that falls under criminal procedure in North Carolina. We have the ability to depose witnesses under civil procedure. If someone doesn't want to comply with the deposition, we could certainly go and do a motion for contempt under civil procedure, or we could use a material witness order under criminal procedure. So we're able to jump between kind of those pieces. We can subpoena witnesses. Those are some of the tools in the toolbox. When the commission presents a case to our commissioners, that is me as director presenting that to the commissioners. It's a non-adversarial hearing. The rules of evidence do not apply. We're presenting all relevant evidence. We're not taking a side on that. It's just non-adversarial. So we are just really trying to give the commissioners all of the evidence. At the 3-judge panel, that is kind of a de novo hearing. It's a new hearing. The parties are presenting the evidence. They can agree to have some of the materials from the commission's hearing presented. Until this summer, it was unclear whether the rules of evidence applied, and most 3-judge panels applied them loosely. This summer, a statute was passed that the rules of evidence do apply. So that's a new law that just went into effect this summer. But that's an adversarial proceeding. The burden is on the claimant, the convicted person, to prove by clear and convincing evidence that he or she is innocent. So it's a reverse burden from a normal criminal proceeding. So it's lower than the burden of proof in a criminal trial. Normally, you've got the beyond a reasonable doubt. This is just below that. This is the clear and convincing, which is somewhat above the civil standard, preponderance of the evidence standard.
Okay, so they're put in a position of sort of prosecuting their own innocence. Is there somebody on the other side? You described the process as adversarial. Is there a prosecutor or somebody on the other side who's defending the other position or taking the opposite position?
Yes, sir. So it is typically the prosecution from the original jurisdiction. There are some exceptions. If they're recused, then the Attorney General's office or a special prosecutor can be appointed.
So it's a retrial of sorts, but from a opposite perspective, I guess I can put it that way.
It's like a retrial, and the decision is binding, so there's no right to appeal the decision, however it goes. If the finding of innocence has to be unanimous, the 3 judges have to be unanimous. So if it's 2-1 for innocence, then it's not a finding of innocence. So it has to be a unanimous decision.
Ultimately, I take it it's the governor's decision as to whether or not to overturn the conviction? Or did I get that wrong? I thought I heard you say earlier that it then goes to the governor of the state.
No, so it doesn't have to go to the governor. If the case doesn't go to that 3-judge panel, there's another process, a motion for appropriate relief process. The prosecution and the defense could file a motion for appropriate relief as opposed to the 3-judge panel process. If they go through that process based on innocence, in order to be declared innocent in North Carolina, then you would have to get a pardon from the governor. So you can either go through this 3-judge panel and be declared innocent, or you can file a motion for appropriate relief. But if you go that route, then you have to have a pardon of innocence in order to be declared innocent and get compensation from the state.
Thank you very much. Monsieur Fortin for 2,5 minutes.
Mr. Fortin, 2.5 minutes. Thank you for the additional half minute. Ms. Campbell, during my last round of questions, we're talking about the timelines, and you said it could take several years. I know that's how it works, but I'm always surprised. We are talking about miscarriage of justice. It would appear that it should be simple. My colleague, Mr. Maloney, asked a question to Mr. Smith, and they talked about the new trial or new process, do you think this process should be simplified? Because once again, we should not be repeating a trial, but simply validating whether or not there was a miscarriage of justice. So given the context, I'm surprised that it would take years to decide whether or not there was a miscarriage of justice. Is this not taking too long? Would it not be better to have a full-time investigation so that within a few months or even weeks, we could arrive at a decision and ensure that justice is done within a reasonable time?
Question. I think that in the work that we're doing, we're looking for new and significant information that could, if it had been used at trial, could have changed the outcome of the actual the hearing or the trial. And so we start with the applicant, what do you think? Could there be something there? And contrary to what people think, DNA is rarely evident in these cases. I think 10% of cases have DNA evidence. So it's like detective work. So you're trying to find first, and as an Innocence Project, we're trying to get a hold of police files and Crown files. And we phone and we show up and we don't get them. And they delay. So I think a commission will have better powers for having access to that kind of information, which would significantly reduce the delay in finding the new matters.
Et quel devrait, à votre avis, être ce...
In your opinion, what should the timeline be? You have some expertise. What timeline will be reasonable to deal with the situation, either refer the case to the court?
Talked about 2 years for her commission, about a couple of years, and I think the CCRC in England has a similar timeline. I think 24 months. Once a case has been accepted to move forward, would not be unreasonable, in my view.
Thank you. And for the final 2.5 minutes to Mr. Garrison.
Thank you, Madam Chair. It's my usual position of having way too many questions and being the last questioner. Mr. Moore raised the question of factual innocence versus what's in this bill. And I want to ask Professor Campbell how you would square some kind of requirement for factual innocence with the charter right to a presumption of innocence.
Oh, my God. That's a hard
In 2
question to
minutes.
answer. Yeah, right. That's a doctoral dissertation. Yeah, okay. I think that you have to sort of draw the line somewhere, I guess, right? I mean, there's the presumption of innocence. It's funny because there's a presumption of innocence at trial and in the adversarial system, but then once you've been convicted, that's gone, right? And I think that then it begins almost sort of an inquisitorial type of practice, right? So the presumption of innocence, you're trying to find the factors that will indicate maybe what really went on. Hopefully, if you have a client who's claiming innocence, it's that. But I think that's a very difficult thing to ascertain. And there are many cases as well. Like I was just thinking when the member Moore was talking about all the Dr. Charles Smith's cases, the pediatric forensic pathologist who was disgraced, and a lot of those were guilty plea cases, wrongful guilty pleas, right? So and they couldn't have been, examined unless we had an open door for that type of re-examination. So I think I think it's better to err on the side of caution with these cases because they're so devastating. The result is so devastating.
And I'm sure we're at a conclusion, so thank you very
You
much.
have a few more minutes if you'd like.
Minutes?
Sorry.
Seconds. Well, the last place I left off with Professor Campbell was on the ability of the Commission to make systemic recommendations, which is not in the bill. So I'm presuming you would be in favor of us adding that to the bill.
100%, yes. I think it's such a great opportunity at this moment to be able to say, okay, let's collect all this data and find out where our courts are getting it wrong, where the police are getting it wrong, where lawyers are getting it wrong, and to do research, to make policy recommendations, to share information with organizations. I think it's imperative, in my view.
Great. Thank you.
Thank you very much to both our witnesses. Thank you for appearing from North Carolina, and thank you to our witness appearing in person from Ottawa. Colleagues, thank you very much. Have a lovely evening, and I remind you our next meeting is Thursday, the November 30th, the last day of the month. We will be doing C321 clause by clause. Thank you very much. Have a nice afternoon.